developed over the years here.
What about the oral tradition of handing on? Have you got any training courses in mind? Is the court before it packs its bags going to go and train lawyers and judges?
We've had ongoing cooperation with the local judiciary for many years now, and to me it's very much a two-way process. Both of us learn from the experience. We have training for prosecutors, training for defence counsel, training for judges, and we undertake that both here at the ICTY, and ICTY staff go to the region as well to undertake that training. I'm not as your earlier comments, Jeffrey, were perhaps a little bit, I thought maybe a little bit negative about the state of the local judiciary. I'm a lot more confident. You've got to remember that just over 10 years ago, the societies in the former Yugoslavia were engaged in armed conflict. We have now, working with the local judiciaries, developed, they have increased their capacity such that they can undertake local war crimes prosecutions. They are doing that now, and all of the states of the former Yugoslavia are at various stages along the path towards becoming members of the European Union.
So you think that when Croatia succeeds, as it may well, in extraditing an alleged Serb torturer from Australia, that the court there will try him with absolute fairness?
I think all of the, I think we have transferred, we've worked with the local judiciaries, and as I say, I think they're all in a very robust state and undertaking their job as experienced and extremely professional members of their profession.
Mm-hmm. Francesca Morelli, let's move to you and to UNICRI, another of these strange acronyms that doesn't tell the whole story, does it? What does it stand for?
UNICRI stands for United Nations Interregional Crime and Justice Research Institute. So as you can understand from the acronym, we are a UN body, and we have a mandate to assist member states to develop policies in the area of crime prevention and criminal justice. So we have rather large mandate, considering that these days crime prevention has become a very large area, which has also many interconnection with security, development, and of course post-conflict. I think today...
how are you going to integrate your work with the Tribunal and its legacy strategy? You've done some work already, haven't you?
Absolutely, and I think a very important point was raised today, in a sense that access to information is very important, but equally important is the management of knowledge, and to create a system through which national experts can really absorb the information that are available. And this will be hopefully the contribution of UNICRI for this project. And in particular, we will be entrusted to develop training curricula for prosecutors, a manual on defense counsel, and a portal containing training courses, e-learning training courses.
You've done a manual on developed practices. Shouldn't that be developing practices?
Absolutely, absolutely. And
the manual on defence, for defence, that's on the way, is it?
Yes.
For defence lawyers, and
that's one of the three tasks of UNICRI.
Have you done a manual on the art of self-defence? Is that yet to come, or is that something we're not going to encourage?
No, the point is that we detected some gaps in this area. In particular, we realized that there was much, let's say, knowledge in the region about the defense issues, and that's why we, together with ICTY and ODIHR, we thought about this manual as a possible instrument, practical tools for covering this potential gap.
Pierre Morel, finally, bring you in as the man with the money. You've heard the legacy visions of around the on the floor. How is well disposed is the EU towards them?
Well, we just heard about the different projects. We are the banker of these activities. But in a sense, although important financially, I believe it's marginal in the overall process. What is much more important, and I hope that Prosecutor Brammertz will confirm what I'm going to say, is the EU leverage, the leverage that the EU has to ensure transitional justice and to ensure cooperation with the ICTY. The full cooperation with the Tribunal is an EU requirement. This is a condition for any country in the region to join the EU. And I think we've seen already that the leverage has worked. So this is much more important, in my view, than the financing of these activities, although they are important themselves. We are also, it was not mentioned until now, but we are also financing or helping the national courts to reinforce the capacity of the national jurisdictions in the countries concerned, and in particular in Bosnia-Herzegovina, the War Crime Chamber, which has been supported financially by the EU. But I would like to echo what Prosecutor Brammertz just indicated, that there is an important loophole, which is the immunity gap, the lack of extradition agreements. And in the coming month, it is our intention to press and push in the countries concerned to make sure that extradition agreements will be signed between the countries.
That's one issue that you're working on. There is a proposal, and it might be interesting for you to consider how it would work into the legacy strategy, for a truth commission. Is there not?
There is, and I had a pleasure to be part of the conference organized last year by the NGOs concerned, the NGOs which are at the origin of this RECOM initiative. We support it fully. As the President said just a few minutes ago, what matters at the end is national ownership. And I believe that national ownership lies with the national courts in the first place, but also in the civil society at large. And only through civil society, through NGOs taking the lead in the countries as a complement to national courts, only through such a movement will the countries be able to explain fully what happened and make sure that reconciliation would be underway. And that answers, in a sense, your question, referring to the 70% in Serbia not aware or not willing to be aware of what happened. And I think it's primarily through the work of these NGOs, which we are financially supporting, by the way, and the RECOM initiative, that this process will be lasting, and therefore, ultimately, that's the legacy of the ICTY.
It's an interesting conceptual situation, because usually truth commissions come first, and hopefully, as a result of their report, prosecutions later. In Sierra Leone, we had a truth commission and court operating at the same time, and we had one or two differences of opinion when they wanted to take over our court and cross-examine our defendants in it. But in this situation, you would be having your truth commission after the ICTY had finished. You would be enabling victims to confront perhaps lesser accusers who may well have done the actual killing, and you may use the ICT material as the basis for a more wide-ranging local reconciliation.
Well, not exactly after, because if I'm not mistaken, the ICTY has not yet completed its mandate fully. And I believe it should, in the sense of handling all cases under its own responsibility. At least I strongly believe in that. And the RECOM initiative has already been launched. So it's coming, you're right, it's coming after the first trials, but it's coming in a sense in parallel.
Would a truth commission or truth commissions, President Robinson, be one way of carrying on the ICTY legacy?
Absolutely. I give my full support to truth commissions. In Latin America, there have been several, as you know, and I myself sat on the National Truth Commission for Haiti in the 1990s. I believe they will complement the work of the tribunal. They will not conflict with the work of the tribunal. And as I said, I wholeheartedly support them as part of the justice system.
You've heard from ODIHR and UNICRI about the prospects for cooperation. What are the objectives from your perspective of cooperation with bodies like that?
Well, the objectives are quite simple. It is to have them provide the concrete means to give effect, to implement the transfer of knowledge from the tribunal to the domestic jurisdictions. I should just comment on the remark you made earlier about the nomenclature, developed practices. You said developing. I should tell you that we deliberately did not speak of best practices because we don't make any claim that the practices are the best. They are simply the practices that we have followed, and it is open to the national jurisdictions to look at those practices and to see what suits them best. And we have had an interesting exchange already with some of those national jurisdictions. They have told us, for example, that in the early days of the tribunal, we would send officers to give lectures on some jurisprudential issue. And they didn't find that helpful because the lectures were given in a remote way. They were not interlinked with the jurisprudence of the national system. So we are learning from the mistakes that we have made. And we are very grateful to ODIHR and UNICRI for providing the means and the resources, and to the OSCE. And with regard to the two projects, the Manual of Best Practices and the transfer of knowledge, I would like to take this occasion to pay tribute to my predecessor, Judge Pokar, because he had the foresight to commence those two projects. So where we are today is very much due to the foresight and work of my predecessor, Judge Pokar.
But there must be some relationship, I guess, John Hocking, between the legacy goals that the President has outlined and the completion strategy that that is already underway. Can you perhaps explain how they're going to go hand in hand or hand in glove?
No, excuse me, absolutely. They are very much intertwined. We at the Tribunal have indicted 161 persons. We have been responsible for investigating and trying those most responsible, the most senior responsible, that is those from the political and the military leadership. But that's just the beginning of the job. There's a Herculean task remaining, thousands and thousands of potential crimes that still need to be investigated and tried, and these must take place by the local judiciary. And so, yes, it's extremely important, that interrelationship between our work at the Tribunal, finishing our work, finishing the most senior responsible, and then passing on and working with the local judiciaries to deal with that remains.
This is a difficult legal concept, isn't it? Those who are most responsible. It crept into the UN language at Sierra Leone where they wanted to limit the number and they spoke of those most responsible. But organizations like Human Rights Watch were very concerned, Serge Bramets, that the people who did the actual killings would get off. is this the class of person that you want prosecuted now?